SJC-13606, Commonwealth versus a Juvenile. SJC-13607, Commonwealth versus a Juvenile. SJC-13608, Commonwealth versus a Juvenile.
Gelson.
Apologize, I'm going to leave this on. I really don't feel great.
That's fine.
Uh-oh.
Good morning. I represent Friedrich F. By including the color of law element in the resisting arrest statute, the legislature provided a limit on police power. To enforce that limit, this court must hold that the Commonwealth cannot meet its burden on the color of law element if the person arrested was exercising their clearly protected First Amendment rights.
Does this case turn on the tumultuous component of disorderly?
I don't think so, Your Honor. I don't think we get to tumultuous, well, I think that the better way to look at this, and we could get into tumultuous conduct and get into those facts, but I think the better way to look at this is that Section 53 and disorderly conduct are circumscribed by the First Amendment. If police officers, if the color of law element does not have some measure of protection for the First Amendment, resisting arrest is a tool by which police officers can quell criticism, punish disrespect, and avoid civil liability.
But you can still have controlment of First Amendment rights if it's a disorderly situation, correct? They can live.
Sorry, I didn't hear the beginning.
You can still have police action that curtails First Amendment rights if there's a disorderly, tumultuous situation, correct? It's not absolute.
It's not absolute, but if you look at Feigenbaum, there is an incredible amount of conduct
The
that
problem
other...
I've got with, I read Feigenbaum, and when you look at that case, that turned on the part of disorderly conduct that had to do with the legitimacy of why they were there at Otis Air Force Base. It didn't have anything to do with the tumultuous aspect of disorderly conduct. That's why I went with that, because I was very curious about Feigenbaum from your fine brief, so I was curious about that. So could you distinguish that and talk about the tumultuous, because that's what the appeals court really relied on.
Right. So none of what my client did rose to the level of tumultuous conduct. I mean, we have a child who is observing, recording, and cursing at police officers who are slapping, kicking, pushing, and brutally arresting his classmates.
But what's helpful, though, is if you look at this in a light most favorable to the government, because that's what we have to do.
Even in the light most favorable to the government, that's what happened. I mean, the officers weren't, they were pretty accurate when it came to their conduct. They talked about slapping and kicking children.
But
so
in a light most favorable, we have police officers come upon a scene of 100 kids blocking traffic, right? That's
right. So I mean that is. And
there's a lot of dispute about that, but that's what we have.
There is dispute about that, and I think certainly, I know I don't have much time, so certainly the deterioration.
You'll probably get more time than you have.
I really appreciate that. Certainly, so the testimony. I think the testimony alone doesn't establish that my client was engaged in any tumultuous conduct, despite any crowd that formed. Putting that aside, if you look at the video and you consider whether or not that deteriorated, particularly Officer Vaughn's testimony, and Officer Vaughn was the person who made the decision to arrest my client, there were several points of his testimony that were deemed conclusively incorrect by the video.
Can I ask you about the lens we look at this? Because normally this isn't a disorderly conduct case, although it is not. Although it is, right?
It is and it's not.
It is and it isn't. So normally we would look at it as we just discussed on the light most favorable on the Lattimore. But here, the overlay is good faith basis.
Right.
So where does that lead us in that analysis? How should that guide us? Is it a lesser standard than Lattimore? Or is it the same standard than Lattimore?
I mean, I don't think it can be a lesser standard. I think it's about how you view good faith and then what evidence the Commonwealth needs to prove to establish good faith beyond a reasonable doubt. Mm-hmm. So it's the Lattimore lens. I agree with that entirely. And if I'm going off base, but I did want to touch upon the fact, and the appeals court touched upon the fact that we're dealing with this tumultuous situation, hundreds of students. And that was by Vaughn's testimony. His testimony was completely deteriorated by the video. He testified that a huge crowd surged in at transcript 142. That didn't happen. That is on the video.
But the appeals court, Chief Justice Green writes the video is only a sliver of the time. It doesn't contain the whole, it's not like we have TV cameras on the whole event, right? So we've got to, again, under Lattimore, look at this. And, one thing, because you guys are changing the names in the brief a little bit, I have trouble. Yours is Fred. Your client is Fred, and he's the one who, again, in the light most favorable, is the appeals court description of the facts inaccurate of what Fred did? I don't.
So I mean, I'll give you a description of what Fred did, and this is what the testimony was.
I want you to light most favorable to Fred, based on the testimony of the police officer. Light most favorable to Commonwealth, the testimony of the police officer for what your client did. Let's just,
Yes.
Because we're going to do that, so don't.
Right. No, and the thing is, the entire time I have been describing exactly what the officers testified to. So he testifies that he is about 10 feet away from my client. My client has observed him make an arrest. He's done with the arrest. He's about 10 feet away from my client. My client yells insults at him. When asked what those insults were, the insults were F you. My client, he says that he tells my client to leave the area entirely. My client refuses to leave the area, says, I'm not leaving, we're not leaving, and he arrests my client. So in the light most favorable to the Commonwealth, those are the facts because that was the officer's testimony.
I'm going to say something a little more qualified than that.
I think there was one additional fact that the police officer testified, and he also added enticing the others to stay.
Yeah, so that was an interesting characterization to me. That felt like a characterization. So he said what my client said, which is, F you, I'm not leaving, we're not leaving. That's what he said my client said. And he puts the characterization that it enticed others to stay. What he didn't say, and what shows up in cases like Sinai when we're talking about the tumultuous conduct, is that caused the crowd to actually do something.
But the question here is whether he had a good faith basis. So his perception that, can you talk about the extent to which it's relevant that he gave voice to a perception, at least, correct or incorrect, that your client's comments were enticing people to stay?
Yeah, so I think you would need evidence that the crowd actually reacted in some way. I think that that's true. But I also think that applying the First Amendment to resisting arrest, which I think we need to do, I think that this court needs to put some First Amendment protections into this resisting arrest statute. And I think that the court needs to do that for a lot of reasons. When I look to cases like City of Houston versus Hill, when I look to cases like Lewis from the United States Supreme Court, they spend a lot of time talking about statutes that allow police essentially unfettered discretion in one-on-one situations to arrest people for their protected conduct. And I think that our resisting arrest statute, I think the legislature has placed a limit on this. I think the color of law element is that limit.
Analytically, how do we do that? Because there obviously wasn't a motion to dismiss on the First Amendment grounds.
There wasn't.
So it comes into the good faith part of it?
Yes, Your Honor.
Okay.
Yeah, I mean, I think it would have to come into the good faith element even in a motion to dismiss. That's the only element that this could really come in through. But the legislature has put that element in. There has to be this measure of good faith. And just like this court has circumscribed other statutes to preclude conduct that would otherwise be protected First Amendment conduct, I think you can construe good faith to include not arresting people for exercising their First Amendment rights.
This is similar to Adams and interference, correct?
Yes, yes, Your Honor.
Which encompasses First Amendment.
Yes, and I think we can, police officers are trained in the First Amendment. They are trained in how to deal with children. I think we can expect this from them. And if you look at Justice Powell's concurrence in Lewis, he talks about the fact that police officers are maybe better able to sort out these kinds of things because of their training and professionalism. So
going to that point, so I think the strongest statement of your position on this First Amendment issue is that, there are a bunch of children in the vicinity. One of them is shouting insults at the police and saying he won't leave. The rest of them also aren't leaving. And the person who is shouting at the police and saying, F you, I'm not leaving, is the one who's chosen to be arrested.
Yes,
which appears to be based on his statements and which arguably are protected speech.
Yes, sir.
I think that the hardest fact for you is that the officer perceived that, I think that that a jury could possibly infer from the officer's testimony that the defendant's comments were contributing to the potentially the situation in a way that potentially endangered people, and that needed to, that I don't know how to fill in the blank there, and I will ask ask the Commonwealth to fill in the blank for that. But that there was a concern created by the effect of the defendant's comments. It wasn't just the comments themselves. So do you think that what facts would have to be in the record for the police to be able to arrest someone who is shouting protected speech, but in a way that is causing a dangerous situation, a la the Markovich case?
Yeah, I think something like Sinai, or I think it might have been Robinson as well, where a crowd forms, or it causes the crowd to throw something, or it causes the crowd to say something, or threaten the police.
What about blocking the area so people can't go by?
So I think that would have to be tied to my client's conduct at that point. We have a situation where my client
But if
is...
there's 100 people in the street, do the police have a right to move them along so people can get home and go to the doctor's appointments, et cetera?
So, yes, and I think in this case, the officer could have given a constitutional order. And in fact, Officer Anderson did give a constitutional order when my client was filming the arrest.
Right, so
He said,
when the
please step back, please step back onto the sidewalk.
The police roll up, they say, everybody disperse, and nobody disperses, and then they get the FUs and the...
Well, I think this is a little different. I mean, this is not simply him standing in a crowd. This is a situation that has escalated. He is observing and recording these police officers making these violent arrests of his friends, and he's criticizing them. So I think at that point, he does have a legitimate purpose for that criticism. He testified at one point that his friend Cyrus was saying that he couldn't breathe because one of the officers was on top of him. He has a legitimate purpose for this police criticism, for this filming. And the police officer could have issued a lawful order to step back onto the sidewalk, to move away. He says leave the area entirely, and my client's response is that we're not leaving. He's arrested immediately.
Doesn't he say that when he's in the middle of the street?
He is in the street. I think.
So he's not on the sidewalk.
No, he's not on the sidewalk. What I'm saying is that the police officer could have asked him to move to the sidewalk.
Right,
Could have
I
asked
think
him
your
to
case
move
would be
to the...
stronger if he was on the sidewalk yelling what he was yelling.
Perhaps. I don't think that necessarily dooms this. And there's, I think.
No,
and
it
I think-
doesn't doom it, but he's not been convicted of disorderly conduct. The question is there a good faith basis? And
I
I'm
understand.
wondering if an officer sees somebody disobeying a direct order and encouraging others to do so, but also is in the street, that the officers came there to open up for traffic to go through, why that wouldn't be a good faith basis to believe that your client was engaging in disorderly conduct.
So it can't be that if somebody's engaging in First Amendment speech, just being in the
But
road.
it's not the First Amendment speech. So it's just to say, he's on the sidewalk, then your client, it's a great case for you. He's not, though. He's in the middle of the street that the officers came to purge so that traffic could go through.
I understand. I mean, I think that I would look to I guess it's Feigenbaum, because that's exactly what those protesters were doing at that point. They were in the middle of the street, they were blocking traffic, and they were doing that for hours and hours and hours. And in other circumstances, that might be disorderly conduct.
A different prong of disorderly, though. That's the problem with Feigenbaum.
But if it
The
wasn't
Commonwealth-
tumultuous conduct in Feigenbaum, how is it tumultuous conduct to be in the street here?
It wasn't argued tumultuous conduct.
Yeah. Well, I still don't think that being in the street alone it gets it here. It's a civil offense, not a criminal offense. I don't know how yelling while you're in the street makes it a criminal offense or arrestable. But I think, my main point is that there are these little factual hitches. It would be better if my client were on the sidewalk. It would be better if the police officer had given a constitutional order. But in the end, my client wasn't doing anything wrong by being in the street and recording these police officers and yelling. And he ends up with a conviction. He is the only person punished in
A
this
lot of other
situation.
people are yelling at the police too at the same time. But
And if
they're not pulled. Only the three people that they sort of feel have gone to another level beyond just screaming, "Screw you, police," the usual stuff, right? That's, it's not like they just singled out the people who said "F you," because that sounds like 100 people were saying "F you," or at least a crowd was saying "F you," go, the usual stuff directed at the police. Your clients are kind of singled out because they take a different step. One person has we're going to hear next about the phone that's 3 or 4 inches away from the cop. This guy, gets in the mix of it as is this happen while they're arresting Manolo?
This is just after they arrested Manolo.
So when he says, "Fuck you, I'm not moving," is that while they're trying to arrest Manolo, or do we not know that?
No, the Officer Vaughn's testimony taken in the light most favorable to the Commonwealth would suggest it's after Manolo's been secured. So I would ask this court to limit the resisting arrest statute in the way that the legislature intended, and to hold that arresting someone for exercising their First Amendment rights is not good faith, and that the Commonwealth did not prove their case against my client. And I would also ask for some guidance on this element from the court and how it interacts with the First Amendment.
Thank you, Attorney Johnson.
Thank you.
Attorney Macon?
Good morning, may it please the court. Attorney Michelle Mencken, arguing on behalf of the juvenile Manolo M. And we're asking this court to vacate the adjudication of resisting arrest, count 2, based on the insufficiency of evidence to support the jury's finding that Manolo engaged in conduct that was cognizable as resistance.
Do we have to change the standard of resisting for that to work for you? Because he's pretty resistant.
I would actually submit that the law does not need to change, that there was a paucity of evidence of his resistance during the arrest, as opposed to the scuffle that happened before the arrest. But during the arrest, there's a paucity of evidence, and even under the law as it exists, I submit that this is a very basic and simple appeal and must be decided in my client's favor.
I'm trying to puzzle through our case law and the appeals court case law and the continuum of conduct. And there's at least a footnote in one of the appeals court cases, and we referenced that the peaceful protester engaged in passive conduct does not resist.
Correct.
And where does your client's conduct in the light most favorable to the Commonwealth line up with the peaceful protester who's engaged in passive resistance?
So there was no direct evidence of any resistance by my client at all. The Commonwealth urged and the appeals court found that an inference could be supported based on testimony that the arresting officer testified that he was trying, that's the word, to place my client under arrest, and Officer Benoit testified that he assisted and that he saw Officer Vaughn trying to arrest my client.
It seems like they conflated the assault with the arrest to get there.
Well, the appeals court decision did not.
Because I read those pages of the transcript, and the lack of evidence is striking, but it seems like they were just assuming it was the case because of the fight.
The Commonwealth's theory at trial was precisely that the whole course of conduct constituted resisting arrest. The Commonwealth's brief on appeal says no, and the appeals court's decision also doesn't consider any of the pre-arrest incidents. Really, the question is, once Officer Vaughn and Manolo are on the ground, what happened? And there's no direct evidence. There's little. There's Manolo's testimony, and there's a video. And Manolo's testimony is that he had a knee in his back and could not breathe.
That doesn't help the Commonwealth on a required finding.
Correct. No, that's true. But it does deteriorate any evidence that was presented on the question. I mean, the Commonwealth urges and the appeals court found that an inference could be made that there was some difficulty in effecting the arrest. I submit that can't be correct. This court said in Commonwealth versus Hart, which is best known as the case that and it's cited in both of the amicus briefs, and it was cited in the recent appeals court decision of Tyson, Commonwealth versus Tyson. But Hart is best known for the principle that a plea judge has to find a sufficient factual basis to take the plea. That was a resisting arrest case, and the proffer was that the defendant resisted, or resisted a little bit, and this court said that's insufficient. That was insufficient to sustain a finding, to support the acceptance of a guilty plea. The facts have to be supplied. There must be, it's a factual, nuanced, case-by-case inquiry.
But
that wasn't
but
enough,
isn't
then
that,
in this
but that
case-
was conclusory. Here, there was testimony that two grown police officers had to work in tandem to put your client under arrest. That's not just a conclusory, he resisted. That's a fact that somebody else had to come help. So why isn't that enough in the light most favorable to the Commonwealth is a reasonable inference that the fact finder could make?
Well, my position is that just because Benoit did assist does not mean that his assistance was necessary. And if the court views the video, what can be seen is that there are two officers, one of them being Vaughn, involved in the takedown of Manolo to the ground. There is a third officer standing by, not involved in any way. He's supervising, he's standing, he's watching. And at some point, another officer comes running toward them, and the standing by supervisor puts up his hand. I'm gesturing as if I'm putting up a stop sign toward the officer that was approaching. That could be interpreted as stand back, we don't need you, but the officer continued to get on the ground. And there's nothing observable in terms of, a struggle or a
Well, there's
need
this,
or an
there's this
urgency
sentence
that
from,
required assistance.
there's this sentence from Benoit, right? Quoted by the appeals court. Benoit came to assist after he observed Vaughn having an altercation with a student from a high school, and Vaughn was trying to get him to comply with his commands, telling him to place his hands behind his back. Benoit assisted with grabbing an arm and putting the hand behind. That's not enough, ma'am?
Absolutely not. It's absolutely not, because number one, putting aside, maybe that tense means, maybe when you say telling him, the Commonwealth maintains that means that it was said repeatedly. I would dispute that. I think it's equally inferable that that's just the manner of speech of the witness. That they certainly didn't say that they made repeated commands. They did not say that they were having any difficulty. They were saying we're
Trying to get him to comply with his commands,
I maintain, to answer your question directly, and then I'll have a second part to my response, but I maintain that trying to get him to comply does not, maybe it means that there was some difficulty. Maybe you could infer that, but the inference has to be, it can't be just some slight evidence to support an inference. It has to be enough to sustain the finding beyond a reasonable doubt, to the exclusion of any equally likely explanations for that. Further, even if there were some difficulty, the Commonwealth would have to have proven, or there would have to be sufficient evidence that the difficulty was caused by Manolo as opposed to something else. This was a loud, chaotic, rapidly evolving scene. Officer Vaughn testified with respect to his the next arrest, that he needed assistance because he was exhausted. He was asked directly, why did you need assistance? And he said in that case, I needed assistance, and I needed it because I was exhausted. They supplied plenty of detail.
From the struggle.
With your client
Well,
who's,
there was a fight. We're not going to dispute that there was a fight. It can be seen on video. Vaughn very aggressively attacked my client, and my client did fight back. But there was coordination needed between the two officers. Placing a person in handcuffs it's not something that is just simply and easily done. But the most important part is that even if there was some incrementally more challenging set of circumstances caused by Manolo, which I maintain there was not proof that anything was caused by him. Even if that were the case, it would have to be the kind of resistance that's contemplated under the statute. The larger context of this is, as illustrated in the party briefing, you have a series of cases, as Justice Gaziano mentioned, where it's elusive, trying to figure out where the line is. But how much more beyond passive resistance does it take to fall within the purview of the statute?
The statute says physical force, correct?
Well, okay, so the statute does, and I'm going to encourage the following reading of the statute, which I'm going to acknowledge is inconsistent with a decision of the appeals court called Katigan, which is an outlier in holding that under the force prong of the statute, any force, any degree of force in opposition is cognizable under that prong. So that means that passive resistance by a nonviolent protester has to be being limp, like a potato sack. And if you do anything to firm up your body, you have thereby used force, and you are now guilty of a crime. But if you just relax, you're okay.
The plain application would be the use of physical force against a police officer is criminalized, correct?
What I encourage, and I have a lot of support for this, I believe, is reading subparts 1 and 2 of 32BA harmoniously and as a whole, which is required under fundamental canons of statutory interpretation. It says you're resisting arrest by either using or threatening to use physical force or violence against the police officer or another, or using any other means which creates a substantial risk. So I think that the parallel construction here with the words using force or using another means, as well as the use of the term other, which refers back to the first section, that you have to read these together. And what the legislature is contemplating is that the degree of physical force that's employed against the police officer has to create a substantial risk. This court and the appeals court have repeatedly.
But they're disjunctive, though, right? 1 and 2 are disjunctive.
Well, but they do need to be read harmoniously.
Well, as I look at it, number 2 means the use of physical force means I thrash or I do something. Any other means that creates substantial risk could be someone that runs out into traffic that causes people to.
I would ask the court, what's the purpose of the term other then? You could say using any means. It says using any other means, which implies that the first clause is one means of creating a risk, and now we have a catch-all.
So you would have the physical force has to have the substantial risk of causing serious bodily injury.
Yes.
So pushing a police officer would not be resisting arrest.
That's gonna reverse a lot of cases.
Well,
out there.
it
So,
could.
right, just the
it
question,
could-
the hypothetical
it
is,
could
so
fall-
if a police officer goes to place me under arrest and I shove him in the chest,
That could be any other means.
but that's
I
not
think that-
substantial physical injury, is it? Unless I'm, I guess, a karate
Well,
master.
according to many decisions of this court, many of the pulling away cases and stiffening cases, those have been determined under prong 2, under subpart 2. So there are many decisions holding that just pulling away or stiffening or refusing to get,
I agree with you.
that creates I may personally disagree with that, but the cases would not need to be reversed under my reading of the statute. So I do want to point out that.
But then it would reduce, I mean, if you're suggesting that substantial risk of causing bodily harm, our cases say stiffening is enough, then it would, I don't see how that would be helpful to any person in your client's position.
I sort of spoke in broad brushstrokes. I don't think that stiffening alone is enough. And I think if you look at the facts that were proven in all of those cases that involved stiffening, there was more than stiffening.
Right.
There
So
were
it's not-
stiffening in
right.
circumstances that created a substantial risk. Just like flight from police on its own is clearly it's been said is not resisting, but
Unless-
flight.
unless it creates a substantial risk.
It's in circumstances that create that.
Right, so
So-
and I've had cases where someone runs across in traffic and people have been injured because the police pursue them and
Absolutely.
tragedy ensues.
And to be honest, I can imagine a scenario, or just going limp like a potato sack, even though that would be called purely passive, could create a dangerous circumstance. For example, if they're sort of lying on thin ice or something. I don't know, I'm just spitballing, but I do want to point out that there is this whole area of jurisprudence that has to do with, like the armed career criminal, it has to do with sentencing enhancement, and it depends upon
But
whether.
Escobar goes to
Right.
recklessness or who the harm is directed to. Here, it's always going to be directed to the police officer. Because it's not, Escobar, classically, is you throw the plate against the window or against the door, it smashes and it hits the person. The violence isn't directed at the person, they're the recipient of the violence. So it's not against the person. That's Escobar in those cases.
So
This
there's
seems much different than that, because I can't think of a scenario where the resistant conduct isn't directed at the police officer, because it's not just in the air.
So there's not a Massachusetts case that I'm aware of that talks about this resisting arrest statute in that context, under that analysis that you've just described. The federal cases, and one is cited in my sister's brief, talks about the federal. I just want to point out that the federal system, when people with state Massachusetts resisting arrest convictions are being sentenced in the federal system, the federal system, having read this statute, is interpreting prong 1 as categorically violent and prong 2 as capable of being committed in a reckless fashion, which is actually sort of the opposite of what our cases currently hold. So I think that inconsistency is worthy of attention. But as I say, I think that...
The federal case law would be better if it said "or other violence."
I'm sorry? If it said "or..."
Focusing on your emphasis on other. The federal case law would be better if it said physical force or other violence, as opposed to just violence. You see what I'm saying? They would tie those two together as opposed to...
That's right.
...making them equally available.
But I get your point, though, that we need to be clear as far as prong 1 and prong 2 in our case law.
And I think that, what I was starting to say before was about the model penal code, which Massachusetts courts have repeatedly said that this should be construed consistent with the model penal code. The emphasis of the model penal code is quite clearly upon creation of a risk of bodily injury. So what I would say is that if you look at the facts of the cases in Massachusetts, there is no case where such a paucity of evidence of resistance as is present in Manolo's case has ever been held sufficient. And that the parentheticals and sort of the treatment of those cases have resulted in a state of law which appears that just stiffening or just a minor, the model penal code says trying to pull away from police is not cognizable. What we're talking about is a dangerous situation. And that should be clarified, because this is, as the brief of the amici, particularly the New England Innocence Project and MacDowell and CJI brief, talk about the danger of arbitrary and discriminatory enforcement, where police have so much discretion and police have a direct role in bringing about the defendant's reaction in this sort of two-party encounter at issue.
Thank you.
Thank you.
Attorney Seeley?
Good morning, and may it please the court. Melissa Chelly on behalf of the juvenile Angela A. What we, myself and Angela A., are asking this court to do in this case is to ensure that the law of resisting arrest maintains its legislatively imposed limitations. We're not asking you to cut new ground here. We're asking you to uphold what the legislature has already said. The legislature could have defined resisting arrest as knowingly preventing or attempting to prevent a police officer from effecting an arrest. But it didn't do that. Instead, that conduct is only criminalized under certain circumstances. First, as Attorney Jellison described, the officer must have been acting under color of law when making that arrest. And second, which is a two-part second prong, the person must have knowingly prevented or attempted to prevent a police officer from effecting an arrest by using one of the two prongs that were previously being described. Those limitations matter, and they matter in this case. I would like to say that I just recently read the appeals court's decision in Tyson. I think that the court in that case really got it right. It imposed the appropriate limitations, and it did so by drawing a distinction between prong 1, the force prong, and prong 2, the substantial risk prong. What it said, which I thought was notable, and I am frankly kicking myself for not having recognized prior to this case, was that force against a police officer, against cannot be read out of this statute. Force against a police officer cannot be affected by a movement away from a police officer.
I have trouble, I mean, again, I haven't reread all these cases, and you may, and I understand the argument that one, you should change the law, change your case law, or two, you should add a First Amendment overlay to this. But we've got all kinds of cases where that, the waving your arms around, trying not to let them, I mean, I was doing this for years. There are all kinds of those cases where we found that's resisting.
So again, in those cases, for instance, in Grandison, we had a case where someone was pulling, there were a few problems in the Grandison.
The tug-of-war case.
No, that's the Katikin case.
Okay, thank
and
you.
I would submit that the Katikin case was analyzed under the wrong prong because it was analyzed.
I didn't mean to distract you. Please continue.
The flailing around cases like Grandison, that was analyzed under whether that flailing created a substantial risk of causing bodily injury. And I did want to come back to something that you, Justice Gaziano, had said during the previous argument, which is, I think you were adding substantial to the bodily injury. But substantial doesn't modify the bodily injury. It modifies the risk.
Substantial risk.
A substantial risk of causing any bodily injury.
Right.
It doesn't need to be a substantial risk of causing substantial bodily injury. So for instance, in Grandison, that case turned on, and what the Tyson court recognized in analyzing the actual facts of those cases and the facts of the Grandison case is that when the party broke free, it created a substantial risk as he was flailing around of, for instance, hitting the police officer, a substantial risk of causing bodily injury to the police officer. And then coming back to the Katikin case, again, that is movement away from the police officer. It's possible, I suppose you could analyze that possibly under either. I suppose a tug of war could be force against or movement away from.
So with your client's cases, and you'll certainly correct me, because there's the one part that's more problematic where she's turtling at the very end. But before that, while she's standing up, they grab her arm and she pulls away?
There's no evidence that they grabbed her arm. What the police officer said, and if I'd really like to read his testimony verbatim, I went over and I attempted to place Angela into custody. She resisted. I put her on the ground. She pulled her hands under her body. Then he clarified what he meant when she said she resisted. I attempted to put her hands behind her back, and she was pulling away from me the first time. That is not evidence that it is possible that he grabbed her and she broke free, but it is equally possible that he did not touch her at all, that she kind of moved away like this, which is actually how I first read that. So there's actually no evidence whatsoever on the point of whether or not he touched her to begin with. Because if we're talking about...
Let me ask you, so if a police officer grabs someone's arm to put it behind their back to handcuff them, and they pull their arm away, is that force against a police officer?
I think it could be. And again, coming back to the Hart case, it is a factual determination. So potentially the length of time that this is going on. You know, the Katikin case talks about a tug of war, which really implies a significant or at least a measurable amount of time that this force is being exerted between the two of them. There's no evidence whatsoever that there was any measurable time here.
So pulling away that testimony, is that the same or different than the passivity that we allow in these cases?
I mean, I think that the passivity, to my mind, is a protester who falls to the ground.
Right.
Is that pulling away? That's not, whether that conduct is the same as an active pulling away, I don't think the court needs to reach that question, because I think that the question here is, when there's no action when there's no physical force or violence against the police officer, toward the police officer, then, so whether that be by passive...
If a police officer is trying to effect an arrest, and the person that the officer is trying to arrest is actively doing something to stop that, how is that not against the police officer? If I'm the police officer and I want to arrest you, and I go to grab an arm to put it behind your back and you pull it away, how is that not against the police officer? As a practical matter and a legal matter, how is that not against?
So I can say, Your Honor, that I actually had this conversation with my husband, who is a physicist, and his opening salvo was, I could draw you a free body diagram of the forces at play in this interaction. A force means that there needs to be something, just moving away, stepping away is not a force against.
But if the testimony had been drawing the free body diagram, with which I'm familiar, if you can read pulling away to mean I grabbed her and she pulled her arm away, would that, under your scenario, be physical force against the officer?
So I don't think so, because I think that, again, we need some kind of time that's, a momentary action like that just is not, perhaps this falls under the knowing prong also, that she has to have knowingly prevented the officer from effectuating the arrest.
Isn't there some discussion about she wants her telephone? They're on top of her.
That's right.
And she keeps moving her hands out they're trying to pull her hands back, but she wants her phone, so she's resisting in that sense. I'm not saying that's resisting in your terminology, the police officer, but she wants her phone. She doesn't want her hands handcuffed.
So she wanted to put her phone away. Her testimony was that she would comply as soon as she put her phone away. And if I could just go on to a little detour for a moment and say, the reason she wanted her phone, the reason she was doing this in the first place, is to forestall what happened in this case, which is that in this case, police officers were allowed to testify, could say virtually whatever they wanted, even though a videotape showed other things, because the videotape didn't show every interaction. Well, she wanted to make sure that she was showing every interaction. That is why she was exercising her First Amendment rights in this case to videotape
I
the
get
police.
that she can videotape, but when she starts putting the phone 4 inches away from an officer who's trying to arrest somebody else, you may be exercising free speech, but free speech have, reasonable time, place, and manner restrictions. You don't get to stick a metal object into a brawl, do you?
Again, Your Honor, that arrest is at least in part shown on the video, and on that video, my client is standing a safe distance away. She is nowhere in the fracas.
Under the Lattimore, you really are going to, we're going to go through the record. We're not going to find testimony saying your client has the phone 4 inches away and they keep brushing her hand away and she keeps sticking it back in.
You may see, there is no testimony, to the best of my memory, that they were pushing her out of the way. There was no testimony.
They're saying, get your hand out of, get the
Yes.
phone out of my face, or
There was,
something like that.
but this is a key distinction, I think, because all of the statutes, any possible thing that I could think that she could have been charged with, notably, the Commonwealth continues to say that she was, quote, interfering with the police officer. The requirement for interfering with the police officer is physical action that actually does interfere with the police officer. So if someone had to brush her away, then maybe you could say that interfered. But if there's no testimony, the only time that interfering comes up is in the Commonwealth's opening statement. No one said that she was actually interfering. She may have been annoying them. I'll give them that. But annoying is not interfering under our case law.
Really, a reasonable inference that when a phone is 4 inches away from your face in the midst of this tumultuous situation, it's not reasonable to infer that you're interfering with their ability to be a police officer in this context?
I think it's...
I mean, she can stand 10 feet away and film to her heart's content. I assume 30 other kids were doing that, and that's why we have all this video. But she's doing something a little different.
Again, being annoyed by somebody is different. Being annoyed that she was there, being angry that she was there, which the police officer testified that he was, being angry, being annoyed, that's not the same as having your job interfered with in a physical fashion. But I do want to bring it back to...
Ms. Jellison's coming up there while you're trying to talk to us and sticking her phone in your face nonstop while you're talking to her. You're not interfering with your ability to argue in front of us?
I mean, I think that I have a very different job than the police officer, and B, again, that would be really annoying.
We don't have a charge of interference, so what's the...
Well,
it's
a common law charge.
Right, I kind of get it.
So-
If you could sum up, please.
Yes. So in sum, we have kids, especially, I can speak to Attorney Jellison's client and my own client walking home from school. They are doing nothing wrong. And somehow, even though police officers were the one to repeatedly escalate this situation, they are the ones who left with a criminal record. That can't be allowed to stand. Thank you, Your Honors.
Thanks, counsel. Attorney Mello Marvel, please.
Thank you. If it may please the court, Elizabeth Mello Marvel on behalf of the Commonwealth. In assessing the sufficiency of the evidence, it's the Commonwealth's position that the appellate court applied the correct standard, and in reviewing the evidence that was before the fact finders, they were able to hear from the juveniles who testified themselves. They were able to hear from multiple officers, and it was their job to assess that. And if there were in reviewing that evidence in this particular forum, light most favorable to the Commonwealth, and if there are any disputes between the testimony between the juveniles and the testimony from the officers, it is not this particular panel's...
Well, I read your...
Be a second jury.
I read your brief, and on Manolo, it seems like the trial was more focused on the fight, and the pages of the transcript, it seems to me a little bit scant as to how he resisted arrest, other than 2 cops went over to him. Can you explain how the evidence is sufficient for his resisting arrest?
Sure. So specifically in regards to Manolo, I apologize, Your Honors. I thought we were doing one at a time, and we jumbled them all together. So
Take your time. We gave plenty of extra time, so you're not going to run out.
thank you. I appreciate that. I think one of the things in looking at all of them, but you're asking me specifically about Manolo, you cannot look at his actions as my sisters have argued, in a vacuum. It's a very nuanced and fact-specific. So you're in a situation that is very loud. One of the juveniles testified about how loud it was himself. The officers testified about not being able to hear each other on the radios. So this was not, a very calm and quiet scene.
But that goes to whether it's tumultuous in color of law. I'm more focused on the resisting arrest and what did Manolo do?
I understand. They did not, I concede that there were details that could have been brought out and made it more glaringly obvious, exactly more detailed what that behavior was. But it was reasonable, as the appellate court found, with the testimony that was there, with, I believe it was Manolo's own testimony, talking about being on the ground with multiple officers trying to arrest me.
Okay, but I'm talking about sufficiency.
It was not.
All right, let's get to the required finding of fact.
Yes.
In a trial
Yes.
where Manolo hasn't testified, what was your best evidence about what he did?
At the required finding of fact at the close of the Commonwealth's case, as opposed to
Right.
After he had testified. The testimony was that he was he was told that he was under arrest. He was refusing to put the arms behind. I believe, if I remember correctly, that it was a turning away. I do not believe that there was a force to the point where another officer had to come to assist. So the appellate court found that the information that the fact finder had from the two officers, because I believe it was two that testified specifically to this particular piece of the incident, was that assistance was needed, to the point where they ended up on the ground. So it was reasonable for them to infer that there was a struggle, that this wasn't something where it was put your hands behind your back, and here the person puts their hand behind their back, they're cuffed, and off they go.
But we allow passive resistance though, right?
Correct.
So what was the physical force that your client was using?
I think it was an inference, given the
defendant was using.
circumstances. I think it was an inference, and I believe the appellate court found that it was a reasonable inference, given the circumstances and the.
I read it earlier. Vaughn was trying to get him to comply with his commands,
Yes.
telling him to place his hands behind his back. Benoit assisted with grabbing an arm and putting the hand. I assume that that's the summary. That's all you have.
Correct, and if you're passively resisting and you're just there limp, someone tries to grab your arm, he's going to grab your arm. You're just not, right? So if you're trying, so I think that's the part where the inference comes in. He's trying to grab the arm, he's not able to.
Isn't your best argument also that it's hard to draw a line between the fight and the resisting when they're telling him he's under arrest as he's fighting with them?
Sure.
I mean, I think that's your better argument, right?
Correct.
It's just, this isn't a case where he's doing something, he's not fighting and then he's being arrested, but he's actually in a fight. And then they're trying to shut him down and they can't. I mean.
Right, and I think that's what I was getting at when I was saying you have to look at the entire picture, not, again, you have to obviously look at the details, but in the context of the entire.
Manolo M's your easiest one. The others gets harder once we move beyond Manolo M. Then we're getting into the young woman who's tiny and not doing very much, right?
Well, I do believe there was testimony from multiple officers that she was inches from their face and that there was.
What is she doing to resist arrest?
When they went to take her into custody, the testimony, as I recall.
Was that she pulls away.
Was that she pulls away.
Yeah. And that could very well be, as counsel was saying, not touching the police, just pulling away.
That's true. However, you have to look at it again in the context, because if it's one individual, one officer in a seemingly calm environment, the simple act of turning away may not rise to that level. But in this particular situation, where they're trying to effect arrests in the street, they've already had one officer removed by EMS because he was injured.
But you have to meet the elements of the statute. So there has to be some physical force against the officer.
Or the possibility of endangering safety.
You're suggesting that pulling away from an officer who's saying, put your hands behind your back.
It could be if I'm surrounded by, if the officer is surrounded by other individuals, one of whom
And there was
has already
evidence of that
tried to
during-
punch them. I'm
Yeah,
sorry?
was there evidence that at the moment of this arrest, they were surrounded by others?
I believe
Such
it was a,
that pulling away
I believe that was
passively
an
would be enough?
inference, because all of the testimony was that across this entire, I believe, 45-minute ordeal, that there were kids all around. Like, there was no testimony that this officer and this one juvenile were off and separated and alone.
So she pulls away, they take her to the ground, and
Correct.
she turtles and just keeps her arms in her body, right?
Correct, despite to the point where I
Is that-
believe a third officer had to come in.
Is that force against a police officer when you have your arms in your body?
Especially when the officer's sitting on you.
How's there force against a police officer in that situation?
Again, I think as the appellate court found, it doesn't have to be force that you're hitting the officer or that you're physically resisting the officer.
It's a use of physical force. We're not even going to get to violence because you certainly don't have that.
Correct.
We have the use of physical force against a police officer. So if a police officer, if you're lying on your stomach and you have your arms within your body so they can't grab your wrists, how are you using physical? You're certainly resisting arrest in a colloquial sense. You're not helping them, but that's not what the statute says. The statute says you have to use physical force against a police officer. So the question remains, how is that physical force if you're on your own stomach and you have your hands in and you're basically turtling so they can't grab you?
That was because the resisting happened.
Before she was slammed to the ground by the officer?
That's what I was going to say, that's
When she pulled away.
correct.
So your case rises and falls on whether or not pulling away is the physical force required by the statute. Because once she's on the ground turtling, there's nothing in the record suggesting that she's exerting force against anybody.
Not at that point, no.
Right. So your
She's
case
not
would be, is there
complying.
any case where we've suggested that when an officer testifies that the arrestee is pulling away without, any force by the officer to take the arm and she pulls it away or anything like this? Is this like the most extreme that we've ever would have approved?
I don't believe so. I mean,
Okay, what is worse?
If you look at
Or what is more minimal force?
Well, if you look at the appellate court decision, and they're citing to Maylott, they're talking about, in that particular case, resisted by stiffening the arm, refusing to put the hands behind the back, and not turning around to be handcuffed. So when they're looking at Angela's actions, they actually use the word coupled, and I guess that's what I was trying to get at, is that you're looking at the individual before she was on the ground, but you're coupling it with what happens on the ground, and again, looking at the totality. And the appellate court did find that was, that a fact finder could find that was reasonable.
Is arm stiffening against the force, use of force? It's certainly not compliance, but it's a use of force.
It depends, I think, on the circumstances, and they do list it as a
There's a tug of war
factor.
and you're flailing around, that's for sure. But if a police officer grabs someone's arm and they just stiffen the arm and they're non-compliant, is that a use of force?
Again, it could be. It depends on all of the other factors. And that's what the decisions are fighting. They're not.
But what if it was exactly as hypothesized by Justice Gaziano? Officer grabs you, says you're under arrest, and you just stiffen.
But that wasn't the evidence that was before
No,
the fact
I'm
finder.
not suggesting that it was. Your evidence is actually not even any touching. Your evidence is just pulling away. So
Right,
I'm not sure arguing the facts of this case is helpful to the Commonwealth. But assuming that there's been some touching by the officer and you stiffen, the defendant stiffens, is that enough physical force?
It could be. There are cases that have stiffening of the arm. The
As
question
one
is,
factor,
as
but
one factor.
alone.
If it's alone, I think it would depend, as the decisions have borne out, it's a very fact-specific, nuanced assessment. that's the only fact, I don't know how to answer that question, where there's no other
So
facts.
our resort is basically the statute and what the legislature intended to criminalize, right?
Correct.
Here's what you've got, right? She was pulling away, Parrott explained, I tried to grab one arm. She yanked away with the camera still going. I tried to put her hands behind her back, she wouldn't. Then he grabbed her by the backpack and her hair and put her on the ground. So you have yanked away with the camera, but does that, and I get that helps you, but do we then have this First Amendment component that we have to sort of deal with, which is, is she yanking to keep filming? And does that, again, hers is a little harder, because she's not just, she's filming. I'm just trying to figure out, do any cases deal with, Figgenbaum or whatever it's called, has a protest going on. She's, in certain ways, filming, even while she's resisting, right? Do we have to sort of build that into this?
I think you can, but again, it goes back to the reasonableness of it. I have two things about that. One is the reasonableness and not interfering. And the testimony from multiple officers, not just one, was that she was inches from their face where they were trying to do their job. And I believe one officer, he was cross-examined, if I recall correctly, pretty extensively about the fact that he had slapped the phone out of her hand a couple of times in an effort to get her away. Later on, the lieutenant testifies about how he saw a woman on a porch filming, and she was making the comment, I have it all on camera. And he was like, that's great, could you send a copy of it? And you have another officer who testified, some kids were physically intervening, some kids were filming. So there were a lot of people filming.
Yeah,
There were no arrests, that no one was being curtailed.
The trial motion judge,
Correct.
trial judge both recognize that
Correct, so
distinctions in the First Amendment activities of these people. One may be completely reasonable, and this may be over the line, right?
And I think that's my argument precisely, is that this was not an issue about the fact that she was filming. It was the fact that she was so close to them as they were trying to quell these other situations in the middle of the street where kids are in people's yards, motorists are being yelled at, they can't pass, and
But
that
that
sort of
goes
thing.
to the good faith, color of law, or whatever the statute says, right?
Right, but it goes
Okay.
to understanding the decisions that the officers made in those, right, attempting to effectuate the arrest. Yeah, as it's been characterized as escalating the situation that the officers, so it's in response to that.
Other questions?
If there are no other questions, the Commonwealth would rest on its brief, and I thank you for your patience.
Thank you, Counsel.
Court, all rise, please. Hear ye,